All right, good morning, everybody, and welcome to today's webinar. I'm Lynn Ladd, and I'm the Director of Programs and Membership with the Ottawa Board of Trade. And we are so pleased to be here with you all today. I'm going to ask our guests to just take a moment and mute yourselves while you can before we begin the presentation. Thank you so much. So a little bit of an update from the Ottawa Board of Trade. I've forgotten to share a slide here, pardon me. The first thing I want to do is acknowledge our sponsors, because we are a not-for-profit organization and we rely on the support of our partners and sponsors in order to bring you programs like today's webinar. So the first thing I'd like to do is thank our community partners, which are Tiger Lily Marketing and the Ottawa Citizen, and our event sponsor, Enbridge Gas, and of course a huge thank you to our presentation partner today, Emond Harnden. We'll talk about them a little bit in a couple of minutes. Right now I want to turn your attention to some of the programs that the Ottawa Board of Trade has rolled out as part of our Ottawa reopening strategy. And you can find further information about all of this on our website under Ottawa Reopening. But we have a number of programs that I think are going to be instrumental in supporting the Ottawa business community. One of them is a business reopening workshops program that we are working on in partnership with Ottawa Public Health. These are industry-specific webinars that will help Ottawa businesses reopen in a safer manner. So we have coming up construction and manufacturing, offices and professional services, retail and vehicle dealerships, and then we've just added a new one. It's going to be for the rural community of Eastern Ontario. So you can find all of those events on our event calendar. We have also, I'm very excited about this program, we have also started as business peer groups. This is going to be a peer-to-peer mentoring program to help Ottawa business leaders solve whatever problems they have facing them right at the moment. This is open to absolutely any business person in the city of Ottawa, and it is absolutely free. The only caveat right at the moment is that the deadline for applications is tomorrow. So if you are interested in participating, please visit our website, go to Ottawa Reopening, and you will find the application link. We're partnering with the Toronto Region Board of Trade to bring a wonderful program called the Recovery Activation Program to Ottawa businesses. The intent of this program is to help businesses be fully digitized from end to end. It is completely free. It's been funded by the federal government and with FedDev, and there's also an application link on our website for that program. And finally, and perhaps most importantly, I want to talk to you a little bit about the post-promise. Post-promise is just for
because of you, not only will we take that off, we'll give you an additional 2% off.
Just going to mute that next. There we go. Lovely. So for the post-promise, this is a national program, and it's being led by the business community. This is not being led by a different level of government. And it's being supported by the Business Council of Canada, the Retail Council of Canada, the Canadian Federation of Independent Businesses, and so on. And the point of the post-promise is for businesses to be able to make the post-promise, which are 5 simple steps for workplace safety. There'll be identification decals and things available that you can post in your business. And the intent is to help end the spread of COVID-19, but also to identify businesses that are safe and instill confidence in consumers. So this is very exciting to be part of. And next Tuesday, on June the 30th, we're going to have a conversation with Laura Hearn, who is the President and Executive Director of the Post-Promise, and Goldie Hyder, who is the President and CEO of the Business Council of Canada. So again, please feel free to join us for that and learn how to do it. We are looking to the entire business community to get on board and support this program, and it's free and very simple to implement. So having shared all of this information, I just want to introduce our presenting sponsor today, which is Emond Harnden. Emond Harnden has been a long-term supporter of the Ottawa Board of Trade, and we are grateful for their ongoing support of our advocacy work. But in addition to that, and more importantly for today's purposes, they are the labor and employment law experts in the city of Ottawa, perhaps even in the country. And we are so, so grateful to have them here today to give us some guidance on today's topic. So I am now going to turn it over to our presenters, J.D. and Kecia, and take it away, guys.
Thanks, Lynn. Good morning, everyone. We're pleased to be here and welcome you to this live webcast that we're presenting in partnership with the Board of Trade. My name's Kecia Podetz. I'm a partner with Emond Harnden, and thanks, Lynn, for that glowing endorsement of our firm. We do an awful lot of labor and employment work. There are many of us. I think, JD, we're up to 40 lawyers in that range now.
Like that. I was number 10 on the letterhead, so that seems like a long time ago.
Yeah, I hear you. And I'm presenting with J.D. Sharp, who's also a partner with the firm number 10, as he's just told you. Today, we'll be discussing two important and essential workplace considerations in the COVID-19 era. First, the temporary changes made to the rules related to temporary layoffs and constructive dismissals. And second, employees who refuse to return to work or to the workplace. You'll know that we don't have a lot of time today, so in many cases, we'll be just touching on the issues, and we certainly invite you to follow up with us if you have more specific questions that you need guidance on. Please note that we're largely focused on provincially regulated employers operating in Ontario. We will briefly address the latest changes to the federal jurisdiction, which were announced just this week. So we'll do our best to respond to questions that are posed in the chat function as we go, but we do have about 35 to 45 minutes of content, and we plan to leave some dedicated time at the end for questions. So JD, just to get us started, talk to us about the current status regarding the reopening of the province for those who might not be completely up to speed.
Yeah, thanks, Kecia. Essentially, in early June, we started to see the government announcing, move towards stage 2 of the reopening of the province, opening up some recreational activities, kind of expanding the range of businesses to reopen, those types of things. Between June 12th and June 19th, a total of 31 public health regions entered stage 2. We've limited the size of social gatherings from 5 to 10 or increased the limit. So what we're seeing obviously is the reopening. We've recently seen the emergency order extended to July the 15th, which again provides the government with a lot of flexibility in terms of some of the things they can do, some of the things they can order during that period. So that emergency order is a tool for them in many ways to let them do some things. And it will also be the underpinning of some of the legislative changes that we'll talk about a bit today as well. So yesterday, I think people have probably heard Toronto and the Peel region were given the go to move into stage 2 as well. So now we're really starting to reopen some of the engines of the province in terms of that standpoint as well. So I think we'll see things start to expand proportionately now. These decisions, we understand, are being made obviously in consultation with medical officers of health and public health officials. And so we're trusting obviously that they're taking into account the science as well as they're doing these things. So that's kind of where we stand from a very kind of high level overview in terms of restarting. Before we launch into it and go a little further, just to let you know the format that Kecia and I tend to do on these webinars is we format this like a conversation that might occur outside of one of our offices, but there'll be a lot less profanity, so we'll try and clean it up for you. So Kecia, one of the things I think that we're looking at obviously is there's this reopening. What measures are being implemented, I guess, to protect businesses, or what types of things are being taken into account? Are there things being taken into account to protect businesses and employees?
Yeah, and I have to say the government is actually moving quite quickly in terms of getting some information out, and I'm sure, Lynn, that the Board of Trade is sharing much of that with your members. But for example, on June 16th, the government released a guide on how to develop a workplace safety plan. If that hasn't already been distributed, we can forward that on to Lynn for distribution. But it's supported by 121 workplace resources, all available at ontario.ca/COVID safety. So it's on that website. It includes information on the use of face coverings as well as applying controls in the workplace. I think in terms of a best practice, that's probably, a starting point, because we know that that's what, for example, the Ministry of Labor would be looking to do as a first step if it's looking to see if you're taking all steps necessary to protect your workers. Similarly, on May 29th, the government introduced much needed temporary changes addressing the temporary layoff and deemed termination dilemma during COVID-19, which is really our main topic of discussion today and the reason why we were asked to present today. To ensure that the necessary tools exist while continuing to support frontline health care workers and protect vulnerable populations, the government has also extended at least until the end of the month all emergency orders currently in force under the Emergency Management and Civil Protection Act, Section 7.0.2 sub 4. So given that the declared emergency has just been extended to July 15th, we expect that we may also see this extended. So I mentioned temporary layoffs, and I'm going to turn it over to JD just to give us a little bit of a sense of what you guys were facing on the temporary layoff front in Ontario before May 29th.
Yeah, and this is really kind of very general terms, but what happened in terms of layoffs pre-COVID, if anybody remembers those days, you were able to lay off somebody for 13 weeks in a 20-week period without it being deemed by the legislation, the Employment Standards Act, to be a termination. That period could be extended to 35 weeks in a 52-week period if you maintain significant payments to the employee. And often that took the form, most often that took the form of continuing their benefits, for example, or if there were pension contributions, something like that. So if you're maintaining that connection, kind of stream of payment of some sort to the employee, you're able to take that 13-week period of the temporary layoff and extend it to 35. The 13, and what happened really, I guess, in the run-up to this change in legislation, our firm had authored a letter on behalf of not just our firm, but obviously on a number of our clients to the government, recommending that they take a look at the legislation because these deadlines were looming. And there's a lot of downstream implications of that if it occurs for the economy, for employers, et cetera. So we sent this letter off and they responded with this legislation because this 13-week deadline was looming. It was kind of coming at everybody, and it was really unclear for everybody what was on the other side of that 13 weeks and what was going to happen. Even just from the standpoint of the fact that the courts are closed. So if you want to commence an action for wrongful dismissal or constructive dismissal, which we'll talk about in a little while, the mechanics of that were a little difficult. So what happened? Yeah, sorry, go ahead.
No, I was going to say, clearly they heard us and they responded. Yeah. What did they do?
Well, essentially what they did was they took our suggestion in terms of changing the legislation, and they introduced a regulation, and this is very important for everybody, Regulation 228-20, Infectious Disease Emergency Leave. So you can look that up. You can check that out on the ELAW's website, and you can find that legislation. But what you'll notice if you do read that regulation is there's a lot of words there. It's drafted in typical terms that we would expect, but it's relatively simple in terms of its effect and impact. And what it does essentially is it provides employers with temporary relief from the ESA's rules on temporary layoff, termination, severance pay, and constructive dismissal. And what it does is it takes your layoff during this period and it converts it into infectious disease emergency leave. So what it means is that deemed terminations aren't going to be triggered in the short term. Now, there's going to be still some long-term implications that we have to discuss and review. But if you were laid off after March 1st, 2020, for COVID-related reasons, essentially the government put that 13-week countdown on hold. So interesting to note that these relevant changes only apply to non-unionized employees. And we'll talk a bit more about that later. So, and I guess, Kecia, when we're looking at this piece of legislation and the changes behind it, and I know you were actually instrumental in having discussions with the government as well, and you're participating on the calls, I guess one of the questions we all had was, why wouldn't you just simply take the 13-week period and make it 26? The format that they adopted was obviously what I just talked about, was basically converting it to infectious disease emergency leave. Can you comment a little bit on that?
Sure, and before I do, I'm just going to note that Lynn's just posted up our COVID kind of information hub, and on there you'll see actually a short newsletter that speaks in detail about this provision, and so you'll be able to get that background there as well. So the government could have just simply extended the time for a temporary layoff, which I think many of us expected that they would do. But instead, they, as you said, deemed them on this leave, IDEL leave, when they do not perform their duties because their hours of work have been temporarily reduced or eliminated due to COVID-19 during that defined COVID-19 period. And so why do it that way and not just simply extend the period of temporary layoff? It's because the COVID-19 period is sort of defined by how long we're in the state of declared emergency. So it means that if it would have had to be extended, or if it will be extended, this regulation already contemplates a longer period. So it's defined as the period beginning on March 1st and ending 6 weeks after the state of emergency in Ontario comes to an end. So now that we know that the state of emergency has been extended until July 15, we know that we're going to have an additional 6 weeks after that. And so in our view, this really provides some certainty for employers who had laid off employees during this COVID-19 period and are hoping they'll be able to recall them back, and perhaps those who are a little bit slower getting ramped back up again. So, really strong position to be in, I think, from the perspective of the ESA. Provides a little bit of breathing room, flexibility, and in fact really means that you're not going to be in the position of inadvertently severing the employment relationship when you had no intention of doing so. The piece, and we'll talk a little bit more about that, is that what this leave is, it's an unpaid job protected leave. So remember, you laid them off, they're now deemed to be on this leave. And it's designated to cover various scenarios where employees would not be performing their duties. The provisions of that new regulation, as JD says, really just piggyback onto that leave that already existed. But one of the questions that's come up, JD, is about benefits.
Yeah, and you should go into your point. I think credit where it's due in terms of the way the government structured this legislation. If they'd done what we thought, which was maybe take the temporary leave period and put out 26 weeks, well, not knowing what was coming, it would have been possible they would have had to extend that again or do something else with it. So the way they've structured it, having that 6 week buffer period after the end of the emergency order, kind of sets this rolling deadline that's predictable, because if you see the end of the emergency order coming, then you've got a 6 week period starting to click. So I think that was good. Now I touched earlier, Kecia, on the issue about the 35 weeks in 52 if you maintain substantial payments like benefits. So what did they do? Because a lot of employers laid their employees off without benefits. In some cases, obviously, employees who may have had a cost share in terms of the benefits plans, because they had the uncertainty as well, opted not to continue their benefits because they weren't sure what they were going to have coming out of pocket. So what can you tell us about how this regulation has affected benefits or impacted on the benefits issue?
Right. So for those of you familiar with leaves under the Employment Standards Act, if employees want their benefits continued, you're supposed to continue them. So the immediate question is, oh no, I issued temporary layoff notices. I wasn't able to continue my benefits. What does that mean? Am I not complying with the ESA? And in fact, the regulation confirms, and it's important to keep May 29th in mind, it confirms that if, as of May 29th, an employee ceased participation in the employer's benefit plan, or the employer ceased contributions to a benefit plan during what you thought was going to be a temporary layoff during that COVID-19 period, you're exempt as the employer from the general requirement to continue benefits. However, and I said May 29th was important, anyone placed on IDEL after May 29th, you're going to need to permit employees to continue benefits and then pay your portion as well. So the regulation also provides two categories in which employees will not be deemed on infectious disease emergency leave. And it's going to be important for you to just at least at a high level know about the scenarios.
Yeah, what are those categories in terms of like what does provide that issue or the exemption?
Right. So so again, keeping in mind that COVID-19 period was deemed to start March 1st. So in the first category, employees will not be considered to be on IDEL if at any time on or after March 1st, the employer terminates or severs the employee's employment. We'll talk a bit more about that. You're still allowed to end employment. If your entire business closes at an establishment, or if you've given or give notice of termination to an employee and the employee gives you written notice at least 2 weeks before resigning, and the notice of resignation is to take effect during the statutory notice period. So there are important exceptions that are built in. And again, as JD says, credit where credit is is due, I think the government did try to think through some of these scenarios. In the second category, employees will not be considered on infectious disease emergency leave if, and again, May 29th is the other important date. So if before May 29th, the employee had already been deemed terminated or severed under the ESA because of their layoff. So that might happen if you were starting potentially in tourism or hospitality, starting to already feel the effects of COVID, and you had laid someone off well in advance of March 1st, and so the deemed termination occurred prior to May 29th. So that's okay. They weren't on IDEL if that happened before May 29th, or if the employee had already been constructively dismissed and had resigned within a reasonable period of time. So again, if those events are deemed to happen or triggering events happen before May 29th, it's fine. There's no IDL that applies, even though it may have been post March 1st. Finally, where an employee has been given written notice of termination and is still employed, i.e. written notice, if the employer and the employee agree, the notice of termination can be withdrawn and the employee can then deem to be on infectious disease emergency leave. So JD, we've talked a lot about sort of the 6 weeks post the end of the declared emergency leave, but then what happens? We kind of know there's what amounts to a pause with respect to layoffs. How does it work? What happens after the pause?
Well, it's a really good question. I don't think we really have the answer to that, Kecia. So that's my part of this will be a bit disappointing. But yeah, essentially we've got this pause going on. It's not a layoff right now. It's the IDEL. And then unless the government does something from a legislative standpoint near the end of this, maybe when they start contemplating the end of the emergency order. And, you know, again, I think based on some of the representations that have been made to them, they understand some of the implications of this. So we may see some further legislation coming. But right now, you know, at the end of that 6-week post-emergency order period, unless there's further relief granted, we are looking at kind of the clock starting again. So you've had this pause period, and the clock will start running again, and you'll be back into, I mean, some employers may only be, you know, have a week left, for example, on their temporary layoff period. Some may have more. So what's going to happen is the pre-existing Employment Standards Act rules are going to apply unless something changes. So then we are going to be looking and facing these potential deemed termination provisions. And, you know, and the implications that come of that, which we're going to talk about a little later, the constructive dismissal type issues and things like that.
JD, just to illustrate that quickly before you go on, if you had laid someone off prior to March 1st, say they've been laid off for 3 weeks, that 3 weeks just pauses for that whole period that they're deemed to be on IDEL. And if they're still off work, once that 6 weeks post the declared emergency ends, the clock's starting at 3 weeks again. But if it's post March 1st, that layoff is starting at 0 at the end of that.
Exactly. Yeah. And it's important. And it's important also, I think, just probably obvious, but to make the point, the usual ESA rules apply if the employee is laid off as a result of complete closure of the business, or if it was, they'd already been deemed terminated before this May 29th, 2020 date, the regulations came into place. So that still stands. So that's kind of the general approach. Once that emergency order is done and the 6-week period is up, then all the clocks are running again and again, unless we get some kind of change to the legislation or indications from the government. We're going to be into that period where we start to talk about deemed terminations coming into effect and what kind of things and impact that's going to have. Now, Kecia, usually when we talk about leaves under the Employment Standards Act, and often we talk about them in terms of pregnancy and parental leaves. We talk about some of the emergency leaves like family leaves in terms of sick, you know, dealing with sick relatives, et cetera. There's a right to reinstatement in those leaves. What have they done with respect to this infectious disease emergency leave? Is there any difference in how that's treated, or what happens?
No, it's the same. On the face of it, it's exactly the same. So when the statutory leave comes to an end, the employer must reinstate the employee to the position the employee most recently held with the employer, if it still exists, or to a comparable position if it does not exist. So we don't know, again, whether there'll be any relief coming from the government on that issue, but thus far it's clear that that reinstatement obligation still applies. And, you know, it's unrealistic to think that all employers coming out of this are going to be in the position to reinstate all employees. So that means, you know, we're going to have some tough questions for you when you're determining who you're bringing back, who you're not bringing back, and ending employment with immediately. Questions like why that person You know, are there any discriminatory reasons that we need to be concerned about? Was there a refusal to work that's, you know, caused you to end employment? Why are you ending employment? And so you just need to think very carefully about that.
Yeah, and just a quick note and example on that, Kecia, before we move on. For example, the temptation and the logical business decision that people might make is, okay, I need 50% of my workforce back. Well, I'm going to take the cheapest 50% of my workforce. I'm going to take the people either who have less time with me and who are lower on the wage grid than perhaps other employees. That may well equate to a younger section of your workforce. So you may inadvertently step into a potential human rights issue if it looks like you have not recalled your older members of your workforce. So there's some of those little minefields that are there that you're going to have to walk through. And this is where you're going to probably want to talk to somebody when you're starting to restart on that front, just to make sure that you're not running afoul of anything and that you can defend the decisions that you're making.
Now, the good news is that if you remember anything from this, it's that at the end of the 6 weeks post the end of the declared emergency, they're no longer on deemed leave, which means there would be no longer a right to reinstatement. Okay, so all the normal rules apply, still keeping in mind being cautious around the actual reason for ending employment. So JD, let's talk constructive dismissal, because I think that was crazy in the news the first few weeks of this. It's fallen away a little bit. And we know that the regulation says COVID-related layoffs and reductions in hours are not constructive dismissal under the ESA. It's very specific. So what does this mean for common law claims of constructive dismissal, an employee who goes to court and claims constructive dismissal?
Yeah, thanks, Kecia. And just to frame this discussion, pre-COVID, let's say you called me at the end of February of 2020 and said, I'm thinking about laying off an employee who's been with me for 10 years. What's the problem with that? And most people look at the Employment Standards Act and they say, oh, look, it says I can lay them off for 13 weeks, no problem, or I can lay them off for 35 weeks, no problem, without terminating them. That's true under the ESA. The problem is, unless you have an employment agreement that limits your obligations to the Employment Standards Act, or specifically picks up on your right to lay an employee off, laying that employee off could amount at common law to a constructive dismissal. And for anybody not familiar with constructive dismissal is the exact same as if you walked into somebody's office and said you're fired. Constructive dismissal is basically saying you've changed a fundamental term and condition of my employment unilaterally as an employer. You dropped my wages, you dropped my hours, you demoted me from manager to something lower, you know, those types of things, fundamental terms and conditions, and you've changed them. And that essentially amounts to the same thing as firing the person if they take that position. And we know that, you know, the Employment Standards Act sets out that you get notice and potentially severance pay. And those numbers are, you know, up to 8 weeks of payment in lieu of notice and severance pay up to a maximum of 26 weeks. What many people don't know is that at common law, we're talking in many cases closer to a month per year of service. So this type of cost that comes at common law from a constructive dismissal is lurking out there still. So that was the situation pre-COVID. I would have told you, yes, there's a risk of it being found to be a constructive dismissal, and you should be aware of those costs and those risks. The change in the legislation is affecting the Employment Standards Act limitations and saying that's not a constructive dismissal. Its actual implications on common law aren't yet fully clear. Since this began, I've had a lot of conversations with my clients about constructive dismissal and the risks when you're laying people off. And I've been telling my clients, basically, there's either going to be a legislated solution, and which we've seen partially done by the government here, and there may still be more, and that may be one of the things that we see emerging closer to the end of the emergency order period, but we don't know that yet. The other thing is the courts. The courts are going to have to deal with this. And it's obviously a larger societal and economic problem, because if you look at the potential implications, you have a whole bunch of employees. Let's take an employer with 50 employees, and they laid them all off. So they go to restart, and all of these 50 employees take the position they've been constructively dismissed. Well, the claims that they're going to make against the employer are probably going to be enough to drive that employer already suffering into bankruptcy. So now you've got 50 less jobs potentially available, and you've got 50 more people dumped onto the job market with less employment available. So it's very possible the courts are going to recognize that too and realize that you know, we have to take a harder line on these types of things than we may have in the past, and realize that it was not the intent of the employer to terminate the employment relationship, and that it was due either to a frustration of argument, of contract argument, that we just didn't have the work, that it would be contemplated that if there was something like this pandemic occur, that it's kind of an implied term of the employment that maybe we would be able to lay you off. How they're going to deal with that is not yet clear. It's an objective test. Would a reasonable person view the actions the employer took as being a termination or a constructive dismissal? So it's still out there. I mean, I'm hopeful that the government may still expand on their legislation and be a little clearer there in terms of the broader common law. And lawyers, as we do, have been debating online and telling everybody that will listen to us about all these potential problems and our own unique solutions to it and what we view as the ultimate outcome. And that is worth about nothing because we don't really know yet what's going to happen. And, you know, we're prognosticating and we're kind of applying our best judgment to the situation. Remembering it's a complaint-based system too. The fact that you've laid off an employee doesn't mean it's a constructive dismissal unless the employee takes that position. And the employee to take that position, you know, is putting their job at risk as well. So we may not.
And JD too, just to add to that, it's complaint-based, but it's also very contextual. You know,
Exactly.
How long are you reducing wages, for example? Is it permanently or is it for 3 months? So I think, again, when you're doing those sorts of things and you're concerned about triggering constructive dismissal, that is another place where you're going to want to seek advice to make sure you're on the safe side.
Absolutely. You know, I mean, we'll obviously be arguing the legislation is very instructive, if not binding. We'll be arguing all these types of things that you couldn't have foreseen the pandemic, so it's an implied term. There's 1,000 things we'll be arguing when and where we have to. But you just have to be aware that the risk is still out there. And once this, you know, emergency order is done and things start, you know, maybe coming even more online, that's when we're going to start to see these things emerge. We're going to start to see these arguments made, and we'll understand the extent and scope of the potential problem. The other thing you've also got, just as a conclusion to this particular piece, is that there's an obligation to mitigate on the part of the employee. So even if they have been constructively dismissed, they have an obligation to mitigate their damages, which means looking for another job and possibly accepting your recall. If you recall them potentially to part-time hours from full-time hours, or potentially if you recall them a little later on down the road. And that will, you know, serve to limit the period potentially of notice and damages. So there's a lot of things that are hanging out there. I think the takeaway from this section is that constructive dismissal still looms as a potential risk from a common law perspective. And so that's one of the things you have to work your way through as you're doing this. And one of the questions I think we're seeing periodically, Kecia, is because of all this, you know, I'm on infectious disease emergency leave and I'm not on layoff and all these things. Can you still terminate employees during this period, or has that been outlawed?
You still can. And those of you who were listening earlier will remember that that was an exception as well. So yes, no prohibition in the regulation on terminations or anything to create a barrier to terminations. Absolutely still possible, but keep in mind that if you're terminating without cause, at a minimum, entitlements under the Employment Standards Act of termination and severance pay, if applicable, would be owed, any contractual obligations. And if you don't have something limiting entitlement, you may also have some common law exposure there.
Okay. And this is going to be a fairly dumb question, but is there any issues with determining if the employee's hours or wages have been reduced? Is there?
Yeah, so, you know, for a lot of employers whose employees regularly work 37.5 hours a week, et cetera, it's going to be absolutely obvious. If they're dropped down to 20, clearly they've been reduced. But the government has set a mechanism out in the regulation where you have irregular work weeks, where someone perhaps wasn't working before March 1st for whatever reason, they were on leave of some sort. So there is an actual formula in the regulation that I will do you a favor and not go through now.
Thanks, Kecia.
Yeah, anytime. So JD, we know that ESA complaints have been filed post March 1st. Some of you may have received them. Some may still be filed alleging constructive dismissal. And so what's happening with these complaints?
I have a whole bunch of notes here to talk about, Kecia, but I think I can summarize it as they're deemed not to have been filed, essentially.
Awesome. Perfect.
So again, kind of the pause button and no, not happening, and off we go. We've done the math and it works, and they kind of basically wait. So that's essentially what they've done.
So JD, before we move on to talking about some of these return to work issues in the time we have left, we noted at the beginning that unionized employees have been completely left out of the new regulation. So what does this regulation mean for employers with unionized employees, or where are these folks left?
Practically speaking, at the moment, they are left with their collective agreements still being binding, and any layoff provisions and seniority protections, et cetera, that are in a collective agreement are still binding. We may see, again, down the road, we may see some legislation imposed to deal with some of these things. But I think the government was very reluctant to interfere in the collective bargaining regime and interfere with collective agreements. And I know, through your conversations with the Ministry of Labor, I'm sure that topic arose. And I think that was really the consensus, is that they just didn't want to touch it, because most collective agreements, have provisions that deal with this. If they don't, they default to the Employment Standards Act. But I think the government really didn't want to touch it. What you'll see in a lot of collective agreements, just by way of example, is, we talk about the 13 weeks and 20 for a temporary layoff, or the 35 and 52. But a lot of collective agreements will give unionized employees seniority protection for 18 to 24-month periods, which means if I've been laid off for 35 weeks, I've still got a long period before I'm deemed to have been terminated by the employer. It's notable, though, that the case law is out there that once an employee gets to the 35-week period of layoff, even if they're unionized, they can take the position they've now been dismissed, and they can demand their payments under the Employment Standards Act. However, that also means they have to waive their collective agreement rights to reinstatement and recall. So it's a balancing act there. If the employee takes that position, they can take it legally. And we may see the government legislate that still. We don't know. But
we're waiting.
Yeah, we're waiting. But they will also have to waive their rights to recall. So you'll be done with that employee and be able to hire somebody new. So,
Lynn, you have a question for us, I think.
Yes, I've received a question through the chat, and one of our guests has asked if you could please clarify deemed to leave versus right to reinstatement.
Sure. So the deemed leave is what the effect of the regulation is. So the regulation says if you were placed on temporary layoff during this COVID-19 period, that's the March 1st till 6 weeks after the end of the declared emergency, then you're deemed, if the temporary layoff was for COVID-related reasons, you're deemed to be on this statutory infectious disease emergency leave. But the right to reinstatement is an aspect of statutory leaves. And what it says is when an employee takes a statutory leave, part of their sort of benefits and rights and entitlements attached to taking that statutory leave is that they have that right to reinstatement to their pre-leave job if it still exists, and if it no longer exists, to a comparable position. So two very different concepts, and good question, and thanks for asking for the clarification.
Yeah. So Kecia, we've talked a lot about the provincial because that was the first to change the regulation and legislation. But our firm does obviously a lot of federal work, and when I say our firm, I mean not me. So can you tell us in terms of just generally what's been done in the federal sector in terms of any legislative changes?
Sure. So this is as of June 22nd, 2020. And the feds did what we had expected Ontario to do, frankly. And what they've done is temporarily extend certain layoff periods under the Canada Labour Standards regulations. So prior to this extension, employees could be laid off for up to 3 months or up to 6 months if a recall date is provided in a written notice. So the amendments, which are now in force, temporarily extend certain time periods set out in the regulations. So employees laid off for a period of 3 months or less, that's extended by 6 months for employees who were laid off prior to March 31st, and all the way to December 30th, 2020 for employees laid off between March 31st and September 30th. And employees who were laid off for more than 3 months with a fixed recall date or a fixed period within 6 months, that's been extended by 6 months or until December 30th, not 31st, sorry, whichever occurs first for employees laid off prior to March 31st. I'm throwing a lot of numbers at you. What I can tell you is don't worry about retaining it all. If you're in the federal sector, please go to our hub. If our alert isn't already up there, it will be shortly. And again, we can send the link to Lynn of the regulation itself. But the key piece here is there's been an extension. It has definite end dates attached to it. And again, the federal sector is getting a bit of relief to avoid the deemed termination.
Yeah, thanks, Kecia. I think, so let's shift. I mean, there's some more
Yeah.
details we can talk about federally, but I think, again, they're
Agreed.
getting into the weeds a little bit. So let's shift to a discussion about employees who refuse to return to work. And we're seeing obviously a number of categories and issues that may be out there in terms of the possible implications of this and the various areas where there's rights for the employer. So before we get started on that, we're going to use the miracle of modern technology. We've got a couple of polling questions for the audience to answer. So we're just going to, that'll also help frame our discussion a little bit. So the polling question that's up now is, have you had any employees refuse to return to work or refuse to work or refuse to return to work for reasons related to COVID-19? We'll just give you 5 or 10 seconds to just input your answer there. And then we'll see the results. All right, what have we got?
Just waiting for a couple more responses
Okay.
to come in. And it looks like we're done now, so I'm going to share the poll results for you.
Wow, couldn't get much more even than that.
That's
Okay.
remarkable.
So yeah, that's very handy. So yeah, I mean, obviously we have people who are dealing with this issue and we're dealing with those types of problems. Now, I think the second polling question is with respect to some of the underlying reasons. So if so, what was the primary reason for their refusal? Personal exposure at the workplace, personal exposure on public transit, exposing elderly or vulnerable member of household through personal exposure, childcare, other caregiving responsibilities, or other. So we'll give you a few seconds to click on that as well. The 50% of you who clicked yes. It was always fun waiting for these polling results to come out.
Yeah.
All right, we got 14% on personal exposure at the workplace, the same on personal exposure on public transit, 29% on vulnerable members of the household or elderly members of the household, childcare at 14%, and other at 29%. Someday we're gonna have to expand on other and figure out exactly what other means, but we'll go on with that. So yeah, so we've got a variety here in terms of what we're dealing with, Kecia. So I guess in broad terms, what happens when you recall an employee and they say they prefer to continue working from home?
Yeah, the $9 million question.
I
So
hope it's not for money employers.
one of the things that's going to come out of the pandemic is that a lot of businesses can actually function properly and efficiently with employees working remotely, including those who never thought they could in the past. Now, I see some of you on this call are service-based and much more challenging in that sector. But, having said that you can function, it doesn't mean that an employer is required legally to permit the employee to continue working from home. You're going to need to untangle whether there's actually a duty to accommodate triggered by a human rights ground, for example, an exceptional childcare obligation or a disability. So the first question you should always be asking is why? Why do you want to continue to work from home? Why don't you want to return to the workplace? And it may be, in fact, like I said earlier, that the work the employee performs just simply can't be done remotely. Perhaps you may do or just continue to pay them for them to not really do much work at all at home. But if it's not productive work, you don't have to continue just because that's how you started in exceptional times. Sorry, Lynn, I think that was one of the no words. You may still need to grant infectious disease emergency leave if they have obligations that require them to remain home, such as childcare or other family caregiving responsibilities. But again, you need to untangle it. You need to ask some questions. So I mentioned childcare obligations, JD. Do tell.
Yeah, as long as schools, daycares, et cetera, remain closed and the employee has no other options to care for their children, there's family status protections under the Human Rights Code and provincial human rights legislation that may give them the right to stay home and provide care. Because obviously, as tempting as it may be when your office reopens to run out the door and leave your 3-year-old at home because you spent 4 months with them, it's not legally proper to leave that 4-year-old unattended or 3-year-old unattended. So you would have the right as an employee to say, no, I have family status obligations and I need to take care of that. And that will trigger a duty to accommodate potentially under the Human Rights Code. The Human Rights Commission has issued a policy statement on the COVID pandemic, and I'll just read it to you because it's at least official. An employee who has caregiving responsibilities should be accommodated to the point of undue hardship, which might include staying home. These caregiving responsibilities, which relate to the code ground of family status, could include situations where another family member is ill or in self-isolation, or where their child's school is closed due to COVID-19. Now, it's important to keep in mind that this doesn't necessarily mean they get to stay home and get paid. If they're able to work from home and they're able to contribute, then obviously you can continue to pay them. They continue to contribute and work. But if they're saying, look, I simply have to stay home, what that's essentially saying is the accommodation may well be permitting them to stay at home and not discriminating against them by terminating, for example. But that doesn't necessarily mean, unless there's some other provisions in your employment agreement, that they get paid for that time. So the usual analysis in these types of cases, childcare and family status obligations under the Human Rights Code, are really difficult from a proof and evidence standpoint, because you're really asking a parent to prove to you that they have no other options. And that means, have you canvassed other daycare obligations? Have you canvassed family members who might be able to make those efforts? What is your spouse doing? Like, if your spouse works alternating shifts, then why can't your spouse be with the child while you are working? So there's a lot of those types of issues are there. And as you can imagine, they get a little intrusive on the family dynamic as well. So you get a lot of pushback. But there's still a duty on employees to cooperate in the duty to accommodate. So they have to provide you the information you need to be able to structure an accommodation, and also to determine if an accommodation is justified in the circumstances. And there's a difference between preference and obligations. You may prefer that your child only stay with your spouse, but your obligation is to provide care for your child. And if a daycare can provide that, that may well be a legitimate objection on the part of the employer. I had one employee in pre-COVID times who wouldn't put their child into available daycare. And they said, no, my child will only be cared for by a family member. Well, the child was 7 years old. So what were they doing all day in school? Unless all the teachers were relatives, that objection didn't really hold much water. So it's important to remember that you're going to have to work through the nuances of these types of objections, and you're going to have to get more evidence, and you're going to have to talk to somebody and try and figure out whether you have a legitimate duty to accommodate here, or whether you actually have the ability to try and bring the employee back to work. But it's also important, and I think one of the things we've been stressing with our clients is, you're going to be frustrated. It's going to drive you crazy. You're trying to restart, and you have employees who are resisting coming back. And the temptation may be to deal with them and say, well, you've quit then, forget it. You're going to have to be a little patient. You're going to have to work through some of these things. So that's one of the important elements, I think, from all of this. So Kecia, one of the other things that we're seeing, I think, in many sectors is employees who've been collecting CERB and don't want to return because they're either making enough money on CERB to kind of fulfill their obligations. They don't really want to come back. In some cases, for part-time employees, CERB may have been more generous than what they were making usually. So what happens there in terms of those types of objections?
Yeah, and it's a real issue. We're seeing more and more of it now that everything's starting to reopen and employers are trying to get up to speed again. And I think it's important to keep in mind that the whole intention of the CERB is for employees who are not working for COVID-19 related reasons. Employees, frankly, who want their jobs and want their employers to continue really should return to work. And so, you need to ensure there's no human rights or infectious disease emergency leave type based rationale that JD and I just spoke about for remaining at home. But if there's not, again, these are some of those, I think, prickly situations where you're probably going to want to seek some advice and reach out to us if you deal with us, because you're going to have to craft an appropriate response to an employee outlining their obligations. And, at the end of the day, you may be in the position of ending employment for failure to return to work when recalled, but such a step needs to be taken very, very carefully. And I see, Lynn, you've just noted that many business owners have found that the CERB is disincentivizing to many workers. And I think that's certainly what we're hearing, in particular in the restaurant and retail sectors, as you've said. Hearing that absolutely. And I tell you I do a lot of work for professional services like dentists, physiotherapists, etc. And really there as well. Definitely that sort of, I'm collecting $2,000, I'm staying home with my family, it enables my spouse to go out to work, and that's maybe either almost as much or more than I was making before. Why would I bother? And they're putting these things in writing. it's not worth it for me to come back. Or if you can keep it so I make less than $1,000, then I'll come back.
On the
So
flip side, they're putting it in writing.
it's lovely. So I know we're getting close, Lynn, to the end. I just think I just have one final question for JD. And JD, I'm going to give you 1 minute to cover what's really a 4-hour question. Can an employee refuse to perform work because they fear getting COVID-19?
Absolutely. The Occupational Health and Safety Act has provisions for work refusal if you believe there's an unsafe situation in the workplace. Most common example, there's a big hole in the floor and everyone's worried about falling through it. But essentially, if the employee thinks that it's an unsafe situation, their job is to report it to their supervisor. The employer then has an obligation to investigate and remedy the situation if there's an unsafe situation. And if that resolves it, that's just fine. If the employee is still not satisfied at the end of the employer's investigation, then the employer has an obligation to call in the Ministry of Labor inspector, who will do the same thing. They will come in and inspect, they will come in and review the situation, and they'll either issue a direction to the employer as to how to remedy the situation, or they'll indicate they don't find there's an unsafe situation. And there's various rules in that process in terms of the employee has to perform alternate work if it's available. They have to remain nearby. And that'll be interesting if somebody's refusing to even come into the office. So there's some issues there. But essentially, yes, you have to go through that process. And again, if you're able to strip it down, have the Ministry of Labor say, no, there's no unsafe situation here, then you are able to say to the employee, well, I need you to work now then, otherwise I may deem you to have abandoned your employment. But if there's an unsafe situation, obviously you have to remedy it. And I think it's also important to really look into, how you deal with these things. And I think one of the main things is when you're inviting employees to come back to work and when you're calling them back, communication is key. Tell them the steps you've taken to protect their health and safety in the workplace. What things are you doing to make it safe from COVID for them? That will help alleviate maybe some of the concerns and anxiety at the outset and may limit some of the work refusals. And, and continuous communication in that regard, I think, is going to be very important. And then you'll at least be able to say you've done everything you can do to minimize some of those work refusals. But it's, again, another area where you don't want to react and say, hey, I need you to come back to work right now. Oh, you're refusing, bye-bye. You will want to look into it and make sure it's not based on Occupational Health and Safety Act ground. You'll want to make sure it's not based on a potential accommodation ground, because those are the areas where you're going to find you're running into trouble. So when you've got a fact pattern that's legitimate, that you've actually got crystallized, then you need to talk to somebody if you're unsure and get some clarity on what it might fall into in terms of the categories and the remedy.
And JD, I think it comes down to, I think a theme we've been tracking throughout this is asking why, right? Why don't you want to come to work?
Pin the employee to a story.
And then you can chase it down, because I can't tell you how many times we have clients after the fact saying, I wish they would have told me. Yeah. And we say, I bet she also wish she would have asked, right? So ask the question, pin them down, and then you can deal with what's in front of you rather than finding stuff out after the fact.
Yeah.
Lynn, over to you.
All right, fantastic. Thank you guys so much. So we have a few minutes for Q&As. Not very often do you get to ask a couple of lawyers anything that you want. So here's your opportunity. I just had another question come in privately through the chat. And I just want to say, if your question is sensitive or private, please post it in the chat to me privately and I'll communicate it to the group. Because we can certainly understand that you may not want to be linked to a specific question. So our question is, what is an employer's option when rehiring when some part-time employees have other jobs in high COVID risk positions?
Yeah, in those situations, you are entitled, and again, remembering that the Occupational Health and Safety Act is your overriding obligation. The Occupational Health and Safety Act has penalties that range in very, very costly fines, but also jail time. If you put an employee's safety at risk knowingly, you can actually face jail time, and one employer has seen some jail time for that type of issue. So that is your overriding obligation. So we always have these competing obligations in terms of privacy and health and safety. So somebody says, you're intruding on by asking me medical questions about where else I work and whether I've been tested and whether I've been exposed. And my advice to clients uniformly is, if you are placed in a position where you might have to violate the Occupational Health and Safety Act on the one hand, or the privacy of an employee on the other hand, violate privacy. We can fix that. We can't fix an employee who's been hurt or killed or injured in the workplace, and all of the penalties that come along with that. So if you have employees who maybe work in long-term care facilities in addition to their other job, if you have employees who are working in multiple locations, I think it's incumbent on you to ask some questions and get some clarity. And to the extent I think your initial questions can be relatively innocuous just to get some information, because they may say, oh, I stopped working there 4 weeks ago. Okay, well, then that's not so much of a problem. Whereas if they say, yeah, I keep taking shifts there, well, now we have a problem we have to deal with. And now we may have to dig and go further. So that's the type of thing. I think you take a staged approach to it. You ask some questions at the outset, very generic questions, just to get a sense of whether you have an issue you have to deal with. And then we have to dig a little deeper.
And I think one of the things that we've seen to a certain extent is employers where you're talking in the health field sector, you're actually by regulation allowed to say, choose where you're going to work. You can only work at one place. But I've certainly had some clients who are saying, I only want you to work for me right now. And so I can give you some extra hours in order to make that happen. So there are some sort of incentives as well, if that's important to you.
We've seen employers kind of competing for employees.
Yeah.
And one employer saying, I'll give you some more hours, but you have to commit exclusively to me. And that's created some very interesting scenarios, but it's out there.
So I've had another question come in privately. This one is, how would you deal with an employee who's collecting CERB, but they're checking their emails and they did a task and they want to put in time for that, but bank those hours instead of getting paid or claiming it on CERB?
Ooh, sounds like fraud to me.
Question.
So I don't know, JD, that makes my spidey senses tingle in terms of saying to an employer that that's okay. So remembering that they can earn up to $1,000 a month. So if you don't have full-time work for them and you don't really want them back, then I'd be clear that they're off and you're not expecting them to do any work. If there is some work for them and you want them to be doing that sort of work, then you pay them, but keep it under the $1,000 threshold so that you're not disentitling them to the CERB. That's really what the government's intention was that if there is some work, but not a lot of work, they can still collect the CERB. But I would say that the third piece is, if you have full-time work and they're declining in order to stay home and stay on the CERB, then we should be talking.
Yeah.
I think we're just about out of time. Before we go, I want to let everyone know that one of our members, they're called IQ offices, they came up with the single best document that I have ever seen on how to communicate what you've done in your business place to make it safe to their employees and also to their tenants and their clients. If anyone would like to see a copy of that document, please send me a message or send me an email later. I will be happy to share it with you. It is an absolute work of art. It was so beautifully done and everything is clearly communicated. And IQ Offices has graciously offered to share it with the entire world. So let me know if you'd like to see an example of that. It might help stave off some employment issues that you may have with your teams.
If the entire world includes Emond Harnden, we'll take it too.
Oh, absolutely. I'm happy to share this with you guys. It's an outstanding document, and they actually engaged a pandemic response consulting company to come in and give them all of the physical requirements that were needed to be changed within their premises. And then they communicated this beautifully to everyone that walks through their doors so that there was absolute clarity. And I think they will not have issues. They will not be a client of you guys, I don't think. Not for this, anyway.
We are always happy if our clients don't have major issues. We're okay.
Exactly.
Yes, indeed. I like it when I don't hear from my clients for a while.
Exactly.
Yep, I'm sure. So I've posted a number of links for you today in the chat. I will reshare them when we send out the notification that the recording is live and available for viewing. And of course, if EH has any more links or resources, please send them to me and I'll make sure all of our guests get them. I can't thank you guys enough. This is a very, very tricky and delicate situation that requires nothing but the highest level of expertise to help unravel. So thank you, JD and Kecia, and of course, Emond Harnden for participating today. I hope everyone has a wonderful afternoon, and thank you so much for attending today.
Thanks, everyone.
Bye-bye.
Stay safe.